This is certainly expected to be a controversial bill, and mostly because the government started into this, I think, for a good reason, to correct some administrative process and procedural problems with the way the Human Rights Commissions were actually operating. As they should, and in fact should have in 1998, they were going to have the Act open to add in the definition of sexual orientation under the prohibited grounds of discrimination under our Human Rights Act. And then, I don't know what happened, but they started to clean out the fridge and added a whole bunch of other things in here that are certainly going to make for an interesting debate. So let me say right from the get-go that I and a number of the people that I represent and many others that are not my constituents are very glad to see the inclusion of sexual orientation under prohibited grounds of discrimination. This has been a long-running embarrassment and sore thorn in our side in the way we look at ourselves and in the way others look at us in Alberta. As a result of a case that started here in Alberta with the Delwyn Vriend case, the Supreme Court ruled that we must extend protection to those who've been discriminated against on the grounds of sexual orientation, particularly as it applies in employment, housing, and access to government programs and services. And the Supreme Court at the time was actually pretty prescient and kind of thought they might have some trouble with this government, and they insisted that not only would they tell the government that they needed to do this, but they would actually insist that the legislation be read as though the grounds were actually written in. And in fact, that has happened in the last period of time. Those who approached the Human Rights Commission with a complaint around discrimination based on sexual orientation have, in fact, had their cases taken up by our commission here in Alberta. But for those that didn't know and went and got the Act out and read it, there was nothing in there to tell them that they, in fact, had protection under those prohibited grounds. Nothing, because it had not actually been written into our Act. So, thank you for finally putting that into the Act. It was long past time, but I'm still glad that you did it. It should be there. And I think it's a real indicator of our Canadian society and Albertan society that we do understand and value that there is a diversity of people, and that it's important to us as citizens that we offer protection to people from discrimination, and further than that, we take a step further in that we offer the services of the Human Rights Commission on their behalf for that. So there was also a number of administrative matters that are being dealt with in this Act, and that's things like the name. When the Act got changed a while back, they added in citizenship and multiculturalism. So what had been the Alberta Human Rights Act now became the Alberta Human Rights, Citizenship and Multiculturalism Act, which also sort of made it a bit confusing about what was actually going on and who was supposed to be served by this legislation. So this is proposing that there be some clarity and remove the references to citizenship and multiculturalism. As we led up to this bill being tabled in the House, the Minister of Culture and Community Spirit was very active in the media, and so were many others, in trying to figure out what was going to be in the legislation. And part of the questions at the time were, who did you consult? Who did you actually talk to about what was going to go into this Act? And at various times we got various answers from the Minister, a whole long list of people that were consulted, although others have come back to me since then and said, boy, if that was a consultation, never seen it done that way before. So I think there's some question there about whether groups actually were asked what they wanted to see in the Act and what they weren't, and how there was whether in fact there was a two-way communication there. But one of the groups that the Minister repeatedly referred to was the Sheldon Schumer Foundation for Ethics. And of course, we're very proud in the Liberal caucus that Sheldon Schumer was an elected member in our caucus for many years in this Assembly, has been a great citizen for Alberta and has given us a great example, and in fact a great legacy with the Ethics Foundation that carries his name. And the Foundation did a very thorough consultation, and the minister seemed very happy to take that consultation as his own. So it was interesting reviewing what the Sheldon Schumer Foundation actually recommended happen with a review and an opening up and amending of the Human Rights Act, and what the minister took and what he didn't take. So they did, in fact, recommend some things like changing the name, and they made a number of recommendations about how the commission actually worked. There's been some administrative suggestions on streamlining that administrative process, clarifying the functions, renaming the commissioners as tribunalists, severing the position of the executive director on the government side, who was actually the same person as the director of the commission. So those were actually the same individual. So you could argue there was a conflict of interest there. Enabling paper review, enabling the chief of the commission and the tribunals to delegate reviews, to appoint panels, restrictions limiting the director's authority. The government's done a number of those things. So let me give credit to the government for what it's done right. And here's the rub. You know, in 12 years in this Assembly, Mr. Speaker, I don't know that there's been very many bills that I could just jump behind and say, yahoo, let's go, lock, stock, and barrel. This government always seems to like to present a difficulty. And usually where I start to have trouble is in examining both the intended and the unintended consequences of the legislation that they propose. So here we have a number of things that I am very eager to support in the legislation, and that is complicated by the other things that the government has included in this legislation. And of course, number one under that is Section 11.1. And that appears in the bill as the bill's section number 9, but it's amending section 11.1 of the actual bill. And it's essentially allowing a parental opt-out. Now, let me be clear here, and most people would have already heard this, but we already have a system in Alberta through the School Act where parents can ask to be notified when certain subjects or issues come up in a teaching classroom situation, and they can give written notification to request that their child is given an alternate instruction module and is not engaged in the classroom instruction for those particular subjects. So we already had a process in place. But what this Act does, Bill 44, is it actually takes something that, as we know, is operational now and falls under the School Act and drops it into the middle of the Human Rights Act. So one, that's an inappropriate place to have it. And I'm just going to read this so everyone knows what I'm talking about. Section 11.11, a board is defined in the School Act shall provide notice to a parent or guardian of a student where courses of study, educational programs, or instructional materials, or instruction, or exercises prescribed under that Act include subject matter that deals explicitly with religion, sexuality, or sexual orientation. So, a school is now under some requirement, if this Act passes, to identify again to parents what might be considered and I listed all those things, but essentially subject matter that deals explicitly with religion, sexuality, or sexual orientation. And then you start to get into a description, well, of how do you consider the word religion? How is that going to be defined? Who does the defining of that? And I don't understand why the government waded into this one, but I've been told repeatedly, and I guess we'll hear from other speakers, that this was a compromise. That it was a political compromise in order to get the sexual orientation written into the Act.